Call to order here. The city desires to accommodate persons with disabilities. Accordingly, any physically handicapped person pursuant to Chapter 286.26 Florida statute should at least 48 hours prior to the meeting submit a written request to the chairperson that the physically handicapped person desires to attend the meeting. Any person who decides to appeal any decision of the Code Enforcement Board with respect to any matter considered at this meeting will need a record of the proceedings, and for such purpose may need to ensure that a verbatim record of the proceedings is made, which record includes the testimony and evidence upon which the appeal is to be based. Any person or defendant who requests to review or object to any exhibits presented to the Code Enforcement Board by the City of Titusville prior to submission to the Code Enforcement Board must stand and state their request to review the exhibits prior to review by the Board at the time their case or agenda item comes before the Board for hearing. Any person found to be in violation of the City of Titusville's Code of Ordinances and given a time frame in which to comply shall, upon compliance, be responsible for contacting the Code Enforcement Supervisor for an inspection to verify said compliance. The violation will not be considered to be in compliance until the Code Enforcement Supervisor is notified and verifies compliance. Okay, we have a Pledge of Allegiance, please. Please stand. Okay.
Yep.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, can everyone please make sure their cell phones are on silent? Mr. Rogers, would you like to swear in the staff, please, sir?
Do you swear or affirm that the testimony you shall give before the board shall be the truth, the whole truth, and nothing but the truth?
Everybody had a chance to look at the minutes from last month?
Yes.
Any corrections or additions? May I have a motion to approve the minutes?
So moved.
Second?
Second.
All right. Moved by Ed, second by Joe. Any questions? Roll call vote, please.
Member Richardson?
Yes.
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Herman?
Here.
Chairman Bell?
Yes. Motion approved. All right. Ms. Chelsea, would you like to start, please?
Good afternoon.
Good afternoon.
The first case listed on your agenda is case number 16-115 for the property located at 5001 River Edge Drive. For this property, there are two violations that have been previously listed and found against this property, which are International Property Maintenance Code subsection 304.10, stairways, decks, porches, and balconies, and also subsection 304.2, protective treatment paint. I'd like to invite Officer Crisco up to the podium to provide the update that was provided by the property owner as directed by this board. At the previous Code Enforcement Board meeting, this board directed that the owner provide progress updates so that we know how far along his progress has been made, and that information has been provided to Officer Crisco. If you could tell the board what information you received.
Yes, we received, excuse me, an email from Mr. Gaudio on August 8th, him specifying he dug out a tree and aligned posts in a way of porch foundation and concrete buggy, backfilled and compacted. He poured the wall foundation, he stripped the south form and backfilled and compacted it. He removed temporarily the wall rebar supports, welded the permanent wall rebar supports, and installed the remaining wall rebar. He redesigned the door and the window bucks per concrete contractor suggestions, and he started building the bucks. That was on August 8th.
As Officer Crisco has read the letter, that is the activity report that was drafted by Mr. Gaudio, and that was provided pursuant to this board's request for an update. This board continued this case until this board meeting today to determine how to proceed at this time. There was no timeline indicated in the message that was given by Mr. Gaudio. I don't know that that was part of the specific instruction from this board to give a timeline or not. One would expect that he would have done so, however, it's absent from his message.
You have something you want to say? You have something on there?
Officer Crisco, if you could come back to the podium, please.
Answer any questions, all I can do is read.
I understand that, but I believe the board may have a question. I'm not sure what it is until they ask.
You had something you wanted to add, Glenn?
Just that I have spoken with the building official, and he has already had some inspections on that work that he is listed as being
So
completed.
he's moving right along.
Yes, ma'am.
Good. Any questions?
That was kind of my question. Is he really making significant?
I'm sorry?
Is he really making significant progress, or is that kind of fluff?
I'll
I mean,
defer to the code enforcement manager
Because it's
here.
been going since, what, December the 12th, 2016?
Yes, ma'am, based on the conversation I had with the building official and his list, he's actually a lot further along than some people may have thought he would have got to by now. So we're getting there.
So could, before the next board meeting, can you go out and take a bird's eye view and take a picture of it?
Would you like me to?
Would you please? I would appreciate that.
No problem.
All right. Any other
Mr.
questions?
Crisco, is that progress sufficient for a 30-day period, in your opinion?
Yeah, per the code manager, yeah, I would say, yeah, give him 30 days, and I'll go there once a week and take a picture, and then you guys can decide the 30-day period. Is that good enough?
Thank you.
Thanks. Do you have anything else to add, Mr. Polson? Do you have anything else to add?
No, ma'am.
Okay, all right, great. So we're moving right along. All right. Okay.
With that, the city requests the board make a motion to continue this case until your next board meeting, if that is the board's desire.
So moved.
Second.
Okay. Moved by Gina, second by Ed, to continue this case for at least another month. Any questions? Roll call vote, please.
Member Richardson?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Herman?
Yes.
And Chairman Bell?
Yes. So moved.
For clarification, for the benefit of the board, the case you just completed, 16115 Richard L. Gaudio, and the next case, I presume, 1737 Clyde Botner Incorporated, both had similar requests by the board to the respective defendants. The decision of the board did not specifically indicate the detail of interaction between the defendant and the city staff member or code inspector, but the discussion, as I recall, entailed a request of both defendants to contact the code inspector or potentially the building inspector, part of the city staff, on a monthly basis. I believe our discussion involved for an inspection. Glenn has indicated that there was inspections by the building official, so he clearly complied with the understanding that I had with both those defendants, that they would show the board, I'm getting the work done.
You're exactly right, because we did, well, I did say that, yes.
Well, just as a matter of, since I won't be here much longer, just my memory of what was discussed at the last board meeting. So just bear that in mind as you proceed forward. I think you're fine with Mr. Gaudio, because with Glenn's supplemental information, he clearly called for inspection, is moving forward through the process to achieve what he wants to achieve with the building permit he pulled, which presumptively is going to create code compliance. And here we go on the next case. That was just a general comment for clarity, because the decision of the board, I prepared it apparently not as clear as I possibly should have, because I didn't specifically say, property owner, you got to call for an inspection.
But it's on record, because they were standing there, and I did tell them that.
Understood. Well, I think Mr. Gaudio is complied with the spirit of the understanding with both defendants. Let's see what happens with our next case.
Thank you very much. The next case on your agenda is similar in nature as the board attorneys described. Number 17-37 is relating to the property located at 505 Short Street, owned by Clyde Botner Incorporated. The officer assigned to this case is Officer Lewis, and I'd like to invite him to the podium to inform the board of any update on this particular property and case. Officer Lewis, have you had any communication with Mr. Botner regarding 505 Short Street?
I have not personally spoken to Mr. Botner. I understood he left a message this morning that he has made some progress on the house. I was by there Friday afternoon and this morning, and I have a picture that may help clarify it some.
Please show the photograph to the board.
Okay, hold on. There we go.
Okay, so this photograph on the podium, what is it showing the board?
This actually shows now that he does have some type of roof covering on this structure.
What's different from previous inspections?
On previous inspections, there was holes in the roof. The roof was actually collapsed in spots there.
But that's not a new roof, right?
Yes, ma'am, it is a metal covering of some kind. Now, to go back a little bit, as of Friday afternoon and as of this morning at 8 a.m., he did not have any inspections on the property for framing, covering, decking, et cetera, for the roofing system.
No permit.
He has a permit, he just didn't have any inspections. Now, he does, in all fairness to Mr. Botner, he does have, I don't know if you'll be able to see it, but about right there is a meter, an electrical meter on the house that they gave him temporary power to work off of. You actually can't see it. There's another little sub panel that comes off of that for them to hook up power tools. And he does have a little bit of work on the other end of the house where he's put some wood up.
Okay.
So going to the question regarding inspections done by the city, has Mr. Botner requested any inspections as of this afternoon?
As of this afternoon, there was no inspection request in the system.
Okay.
Is he aware that he is supposed to be, I'm sorry, is he aware that he is supposed to be calling for periodically inspections on a property, or?
The owner was directed by this board to call for an inspection and to communicate the progress that has been made before this meeting, as of the last meeting where he appeared before this group. Has any communication been initiated by Mr. Botner?
Not to me personally.
To the code enforcement manager?
No, ma'am.
And to building services, neither.
No, ma'am.
Who did he call? You said he called somewhere.
No, he didn't call anybody.
Member Richardson, if I may.
Oh.
He emailed a update that said he has progressed, and it came in after we got up here, and I was unable to print that out.
Okay.
Did he
But it
email
didn't-
that to you,
it
Mr.
wasn't a
Tolleson?
It wasn't detailed, just that I have made some progress in updating y'all as he was assuming that was his requirement. And again, as Officer Lewis testified to, the roof and the power are both improvements from the first time the board hearing it.
All right, does he have to have an inspection on that roof after that roof goes on?
Yes, ma'am. At some point here in the near future, he will have to have that inspected. And there would have been one, and there was an electrical inspection on that panel.
There was or was not? There was?
There was, before they would power it up.
Okay.
That date, I don't know.
How long, is there a time frame as to when he has to have the inspection?
No, as
Or is it
long
like
as he's
90 days or
progressively
60
going, he's
days?
got 6 months to do it.
6 months.
Okay.
The city's building permit expires January 6th, 2019.
So he can, up until then, to actually ask for an inspection.
So even though the roof is on, he doesn't have to have it except within that 6 months?
Yes,
So he can ask for it for January 18th next year?
Right, and if you recall his testimony at the last meeting, he said he was going to be done in three months. So
Huh, he got a long way to go.
he's got some work to do, but there again, we're whatever direction this board provides us, we'll be happy to do.
Okay. Well, thank you for the picture.
We'll submit this photograph into evidence. This photograph was taken on Friday, is that correct?
Yes, ma'am. That was Friday, thanks, I'm sorry.
10th, August 10th. Y'all have any other questions? All right, what do you want to do?
I know that metal roofs are expensive, and it looks like he's going through. I just want to give him the benefit of the doubt and continue this for another month and maybe reach out to him and just advise him that he should be in contact with our code officers and just to make us happy and everybody else happy in the city when it comes to this.
If you're gonna make
Yeah.
a motion to that effect, I'd second it.
All right, is that a
Okay,
motion?
can I make a motion
you
just to
did.
continue this for 1 month and
Yep.
and have them reach out to him and see what's going on?
Second.
All right. Motion by Ed to continue this case for 1 more month, second by Joe. Any questions?
Yes,
Yes, sir.
I don't understand, reach out to him. What,
I'm sorry, have the code officer either go by there and speak with someone or send them a note or email or
Actually,
something.
I would prefer that you say to have a written correspondence with him via either email and personal contact, if we can get that. However would be easiest for the board's order.
I like that. Thank you.
So amend it to say that?
well, what's that again you just said, Glenn?
That we have some written documentation via email as well as an attempt to personally contact, because that's not always as easy, but the email we do have, and we can email back and forth quite easily.
I'm not disputing Glenn's request, but again, my understanding and the discussion with both defendants in this case and the prior case, and as I recall, they were both present,
Yes, sir.
was that they would have an
Contact us.
inspection monthly by a city representative, was
Correct.
my understanding.
Well, yes, we will be inspecting them on a monthly basis.
Well, my understanding of the discussion was that it was the responsibility of the property owner to contact the inspector to come inspect.
That's
So
correct.
there would be coordination of
That-
schedules.
Yes, sir, that would have been what we had hoped for. But I have no problem with this going with Member Monis's. We can email them and still do all of those things that are already in the motion, or in the order. We'll do that, the inspections.
I'm not disputing Glenn's request. I'm just stating my recollection of what was discussed with both defendants. The case shall be continued on a monthly basis, and the board requests the defendant to, if you wish for a written report, I'll put that in your decision, or you can say you request the defendant to contact the code inspector for a inspection.
Or for something that we can visually see what he's doing, that know that, yeah.
I'm not trying to push you one way or another. You all get to decide what you think is appropriate to timely obtain code compliance by the defendant. He said he'd be through in 3 months, and that was
That was,
1 month
July
ago or
ago.
2?
Yeah, just a month ago.
do you have a question?
May I ask, refresh my memory, please. Was there any other areas of this dwelling that contributed to the unsafe structure besides the roof?
Officer Lewis, could you approach the podium?
I believe there were, but I can't recall what they were. And if so, has any progress been made on those?
Can you describe the life safety issues with this house?
At the time, the roof was collapsed in. There's some problems with the porch framing up front, even though part of the porch is concrete and concrete masonry units to make up the wall. There's some issues with that. There were some issues with the windows being unsecured at that time. There was also an issue of a door, the floor being, having large holes in it around the door, the front door. I did not see any holes as of Friday there around the door. Whether or not it's been repaired or whether the door's just been repositioned, I can't really tell.
So you're saying all of those other things have been addressed?
They
Mostly?
appear to have been temporarily. Yes, ma'am.
fixed. But I do have another question of clarification.
Okay.
Because everyone keeps saying a roof, and when you testified, you said a metal-like thing, or you didn't say an actual roof.
Is the covering that's on the structure a
Do you
roof,
consider that a
Officer
roof?
Lewis?
Because you were very carefully wording that.
May I, sir? Not to give you a long-winded answer or seem out of place, Member Beckles, 18 years as a building inspector in another state. Still have International Code Council credentials, but the state of Florida says I may not make that determination as a building inspector.
Right, I understand that
So-
the
but,
city inspector has to make the final, I understand that.
It is just a roof.
Your opinion, just your opinion.
My personal opinion, the way I look at it now, is just a roof covering. I would not call it a roof system with approved bracing, framing, et cetera.
Okay.
But I have not seen the underside of all of it. So from what I can see around the outside, I would not call it a complete roof system, only a covering.
So
Okay.
these temporary corrections, if there were any, would not pass inspection? Or
That I cannot truthfully answer for you, sir. That's up to the building
they
inspector,
would have to be approved, though, in the end?
by the building
Ultimate.
inspector.
Building inspector, yeah.
Okay.
Approved materials, methods, and construction.
Okay, thank you.
And again, that would have to be something from the building department.
Building
to sign.
department, I understand they have the ultimate determination.
Thank you, sir.
So, we're good to, all right, we need a roll call vote.
No one seconded
Not
that.
yet.
No, 2 seconds.
Mr. Chair,
All right.
I understand the case is to be continued monthly, and the board requests the defendant to what? I'm still not clear
okay.
on what you're wanting the defendant to do.
He needs to report to somebody is what he's done, whether it's to the building inspector or whether it's to the code enforcement, to let them know that he's moving right along, and the picture is great. That says a lot.
So you want to say that he needs a report by email to the the code enforcement?
A written request, or can we say a written request as to what his progress is, not just, I'm doing progressively, but we need to know what he's done. We need an exact,
But who to send to the code enforcement
send it
officer?
to code enforcement.
So I think this will help. Your order reads, this case shall be continued until the August 13th, 2018 next scheduled meeting of the board. A representative of the defendant shall appear at said time and place to provide a monthly progress report or allow the city code enforcement officer to speak on behalf of the defendant regarding monthly progress reports. Clyde Botner agreed to until the violation of the Code of Ordinances of the City of Titusville as previously determined by this board has been corrected or eliminated, the written satisfaction of the code enforcement officer. And it shall be the sole responsibility of the defendant to contact the City of Titusville Code Enforcement Department at their phone number to request a code enforcement officer to re-inspect the property each month to verify
Okay.
progress is being made until the violation has been
Well,
corrected.
then he hasn't done that.
He hasn't done that.
That's why I'm asking for
All right, then we need
clarification.
to clarify to him, he has to call code enforcement to come out and do an inspection. Bottom line,
Yes, ma'am.
Not just leave a
That's-
message on the voice.
not to leave a message on the
Well,
phone.
we can go with what we have.
Yeah. Because between the two cases, the first one, it was very detailed of what they have done, and the building inspector's been out there. Here's a picture, there's a roof covering, da-da.
Right. And we're still going to follow that up with an email
Okay,
as requested.
okay. All right. So you amend your motion, please? Who did it? Ed did it?
I did.
Ed, okay. Amend it to include that he has to contact code enforcement office for an inspection.
Monthly.
If I may interrupt and make one minor recommendation to that motion, that the language indicate that the owner re-inspect the property, that he request by the Friday prior to the code enforcement meeting rather than,
And the last minute,
the hour
yeah.
before,
Yeah.
because that is the case with this property owner, that he did not contact the city until this afternoon, which was too late to appropriately respond to that correspondence. So if we could include Friday prior to,
I think it's a good idea. I like that, yeah.
thank you.
I like that too. Mr. Rogers, would you get that, please?
Yes.
We've got to-
All right, okay.
Thank you.
Motion, who's the did second?
I did.
Okay. All right, motion's been made and amended, second by Joe. Any questions?
For clarity by the board, before you vote, I will, basically, it will read, case continued monthly, board requests the defendant arrange for an inspection by code enforcement officer by the Friday before the next board meeting, and that the defendant appear before the board or allow the code inspector to appear before the board on behalf of the defendant and speak for him. That's what I was trying to suggest to both property owners. Come see us if you need to talk to us, but if you make the code inspector happy out in the field with the work you're getting done, then the code inspector can toot your horn and say what a great job you're doing since last month.
Okay.
That's all there was to it in my mind.
Any other questions, concerns? Roll call vote, please.
Vice Chairman Beckles,
Yes.
Member Grant,
Yes.
Member Moniz,
Yes.
Member Herman,
Yes.
Member Richardson,
Yes.
Chairman Bell.
Yes, motion carried. All right. Next case, Chelsea.
Okay. The next case on your agenda is case number 18-73 for the property located at 4105 Hood Avenue. This case was previously continued a number of times, so it is essentially new business that I'd like to present to you at this time. Officer Crisco is the officer associated with this case. Before I go into it, I'd like to let you know that the city wishes to withdraw a certain number of the violations listed on the agenda for this case. The city is intending to withdraw section 6-56 permit required. The city is withdrawing section 12-23 junk and debris. The city is withdrawing subsection 301.3 vacant structure and land. And the city is withdrawing subsection 304.13 windows skylight, leaving what's listed as number 4 and 5, subsection 303.1 swimming pool maintenance, and subsection 303.2 enclosures for the pool of the International Property Maintenance Code. Those two remaining violations are what we intend to proceed with this afternoon. And again, I have Officer Crisco here to provide testimony regarding 4105 Hood Avenue. Officer Crisco, did you have an opportunity to inspect the premises at 4105 Hood Avenue?
Yes, I did on February 13th, 2018.
And did you find this property in violation of the Titusville Code of Ordinances?
Yes, I did,
And what was the nature of the violation?
what you specified earlier. I don't have my list.
Okay. Did you provide the notice of violation to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
Yes,
Do you have an affidavit attesting to the proof of mailing regarding this notice of violation?
yes, I do.
Please submit the proof of mailing and affidavit as to notice into evidence as exhibit number 1. Did you re-inspect the premises to determine if the property was in compliance with the violations as cited?
Yes, on February 28th.
Was that your initial or your
No,
subsequent?
the initial was February 13th. The follow-up was on February 28th.
And
No, actually, March 5th. I'm sorry. March 5th was the follow-up. I had contact with the property owner on February 26th. Sorry.
and what was the follow-up with the property owner about?
The property owner who was out of state was not aware of the condition of her property. She had paid a contractor some upfront money to correct the violations, which were original violations. And she said she would have a contractor call us. This went on from February 5th, March 5th, March 19th, nothing was done. April 2nd, nothing was done. Then we decided to send it to Code Board. This is just a short summary. On April 3rd, and then on April 20th, it was still in violation. April 30th, I talked with a representative, Jackie, of the owner, explained the violation, that something had to be done. She said she will do it. So we continued the case in April. And it went on again until May 8th. There was no change. Parts of there was some correction. It wasn't to my satisfaction. Cleanup was started on May 11th. Again, talking with the owner, talking with the property manager, little bits and pieces were done. And out of the blue, I talked with a contractor on June 1st, who said he was in the process of getting an electrician and a worker to put together to get a permit for this house. And here we go back to June 11th, no permit. June 18th, no permit. July 2nd, spoke with Steve Adams in the building department, who stated that he was working with the contractor to put all this mess together, no other way to put it. And I gave him another month, and here we are at July 23rd. We still don't have a permit. Spoke with the contractor. I gave him a deadline of Friday, last Friday, to come up with a permit. And no permit, and here we are. Did inspect it today, and out of all those violations, we only have 2 left. And I'll show you some pictures if you would like. That's the front of 4105 Hood. Here's a green pool in the back with the screen enclosure that's all torn apart.
When were these photographs taken?
This morning, I'm sorry.
Okay.
And that's just the backup of the pool and the screen enclosure, because that's all left. They did do some work. Like I said, we corrected everything else, but the pool and the screen enclosure.
Okay. That last picture you just put up, around that back of that screen?
This is all torn apart.
Okay, but on the outside, is that overgrowth that's not been taken care of, or is that something else?
That's next door neighbor. Those are trees and everything else.
Oh, okay.
You can see the fence line is right over there.
Oh, okay, I see the fence now. I didn't see
that's
it.
next door.
Okay, all right.
Please submit the photographs and evidence as exhibit number 2.
Let me ask a question. You said, but your testimony is that the permit required is gone, that they have a permit now, right?
No, no permit.
Originally, when we started this, there was, the walls were gutted out and there was wiring that was put in there. However, it was stolen. And so we just backed off on that there one.
Okay,
It's
so,
not to say this ain't gonna be
so they didn't
done.
come in and get a permit, you're just withdrawing that?
Yeah.
Correct, got it.
To your knowledge, is the house occupied or is it vacant?
Oh, no, it's been vacant for 2 years.
Okay.
Since the storm.
What are still active alleged violations in the complaint? 303.2 enclosures, pools, got that. What's the other one?
303.1 pool, 303.2 enclosures.
303.1 swimming pool maintenance is the first listed.
Number 4, number 5.
So 303.1 swimming pool maintenance and 303.2 enclosures are what is before the board now. Okay, thank you.
Sorry for the confusion. Photographs should be going down the line if you haven't seen them yet. They will be there shortly. Officer Crisco, based upon your several inspections, did you file a complaint?
So we're just looking at
Yes,
Did you issue a copy of the complaint and a notice of this hearing to the owner of record by first-class certified mail posting the same on the property and at City Hall?
yes, I did.
Please, do you have an affidavit as to this notice?
Yes.
Please place the proof of notice and affidavit into evidence as exhibit number 3. And as of this morning's inspections, which violations still exist?
Under the 6109 Property Maintenance Code, 303.1, swimming pool maintenance, and 303.2, enclosures.
Thank you. Do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
Yes, $410.88.
Please submit the cost recovery statement into evidence as exhibit number 4. Thank you, Officer Crisco. Does the board have any further questions for staff?
Oh, yeah, I would want to be around. Look here. Yeah, there's the property line. That was
Be considered,
all the way. Looks like crap to me. Okay, what do y'all want to do? Okay, go, Ed.
Okay, I move that the board issue the following finding of the fact in case number 18-73, relating to the defendant, Harriet S.A. Woods. The defendant was properly notified of the violation as alleged in the complaint. The defendant is the owner or in possession of the real property located at 4105 Hood Avenue, the city of Titusville, Florida. The defendant is in violation of all the following provisions of the Code of Ordinance of the city of Titusville, Florida.
Four and five.
Please?
4 and 5. You need to list the ordinances. I mean, it's the violations.
What, you want me to read the
Just the 4
violation?
and 5.
The defendant is in violation of the following provisions of... Oh, I'm sorry, I read the wrong one. Okay. Section 6-109, property maintenance, subsection 303.1, swimming pool maintenance, and section 6-109, property maintenance, subsection 303.2, pool enclosure. Yeah, I guess that's in pool also.
Yeah. Pool maintenance, that's the 4 and 5, yeah.
You're finished with your motion?
Yes.
Second.
Motion by Ed, second by Gina. Any questions? Roll call vote, please.
Chairman Beckles? Oh, sorry, Vice Chairman Beckles?
Yes.
Member Moniz?
Yes.
Member Richardson?
Yes.
Member
Yes.
Grant?
yes,
Member Herman?
Yes.
Chairman Bell?
Yes, motion carried. Next motion, please.
I move that the board order, issue this order to correct relating to the defendant, Harriet S.A. Woods, adjudging the defendant to be in violation of the sections of Code of Ordinance of the city of Titusville as determined in the finding of the fact, giving the defendant until 9 a.m. on September the 10th, 2018 to correct the violation to written satisfaction of the code enforcement officer or to appear before the board at City Hall, Titusville, Florida on September the 10th, 2018 to show cause why the violation has not been corrected and why this board should not proceed to impose fines for the violation. The defendant is ordered to pay $410.88, which represents the cost incurred by the city of Titusville to bring this case before the board.
Second.
Okay, motion by Ed, second by Gina. Any questions? Roll call vote, please.
Member Richardson?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Herman?
Yes.
Member Monis? Member Herman?
Yes.
Yes.
Chairman Bell?
Yes, motion carried. Okay. What are you confused about? Everybody said okay, so we're all, that's okay. We got it. Okay. All right, so this one has been assessed.
I'm sorry?
The city costs have been assessed on this one. Just so everybody knows.
She's just saying that,
We
he did
assessed the city cost on this one. They've been assessed, so she's got to pay them.
Yeah.
All right, well, we do that sometimes. All right, next case, please.
Next up, we have number 18-91 for the property located at 2230 Anna Drive, located in Titusville, owned by the defendant ASP Ready Chem LLC. I have Officer Lewis here to go into detail as this property is still in violation. Officer Lewis, if you'd like to join me up at the podium. Have you had an opportunity to re-inspect the premises at 2230 Anna Drive to
Yep.
determine whether the owners brought the property into compliance?
Yes, I have.
Is the property still in violation?
The property is still in violation.
What violations still exist on this property?
They still have the roof. I'm sorry, I got the wrong paper, don't have my list. Okay. Section 106-9, subsection 301.3, vacant structure and land. 6109, property maintenance, subsection 304.7. And section 12-23 of the Titusville City Code of Ordinances, junk and debris.
Has there been any change to this property since the last meeting?
None whatsoever.
Have you had any communication with the owner since the last meeting?
None whatsoever.
Does the board have any other questions for Officer Lewis?
Is this vacant property, sir?
Yes, sir, it is still vacant, it is still unsecure.
And no communication with anyone?
No, ma'am, none whatsoever.
The board previously ordered the respondent to pay the costs in the amount of $375.66, and the property has not been corrected to the officer's satisfaction. And as we've heard, no progress has been made whatsoever.
None.
Is this one of those properties that could be put on that list for cleanup or pushover or whatever?
Yes, ma'am.
Because it could be a demo property?
Yes, ma'am.
What do we have to do to move it along, and since nobody's responding?
This would be the start of that.
This would be the start of it?
Yes, ma'am. And then,
What you may do with other administrative remedies of the city is the city's purview. The board just needs to take care of its business, listen to the evidence presented. If you find a continued violation, then determine what you think is required to achieve code compliance. In other words, normally, one would find, if you believe the testimony presented, that there's a continuing violation which warrants final judgment if you feel that it's...
So we can go straight to final judgment on this one? Okay.
This is the second reading.
It might be.
This is your second reading, right?
Well, we're going to final judgment on this one. Yeah. All right. Who wants to make a motion?
May I ask
Yeah, go ahead.
a question, please?
Sorry.
How long has this case been on before the board? How long? I mean, when was the initial inspection?
I actually opened this case in March. This property has been vacant for several months before March.
Okay.
It's been vacant probably at least 9-10 months. And it's been spotty in occupancy since I come aboard in 2015.
Okay.
I'll make a motion.
Okay, go ahead.
I move that the board issue the following findings of fact in case number 18-91 relating to the defendant, ASP-Ready Chem LLC. The defendant continued to be in violation of all of the sections of the Code of Ordinances of the City of Titusville on, today is what, August 13th, 2018, as previously determined by this board.
Second.
Motion by Gina, second by Ed. Any questions? Roll call vote.
Member Richardson?
Yes.
Vice
Yes.
Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Herman?
Yes.
Chairman Bell?
Yes, motion carried. Next motion, please.
I move that the board issue its final judgment assessing fine and imposing lien relating to the defendant ASP-Ready Chem LLC based on the findings of fact issued this date, and that the judgment contain the following provisions. The defendant is assessed in order to pay a fine of $100 per day per violation for each code section violation. The fine shall commence on, when was the order to correct? The initial order to correct?
By
August the 10th.
The fine shall commence on August the 10th, 2018, and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
Second.
Motion by Gina, second by Ed. Any questions? Roll call vote, please.
Member Herman?
Yes.
Member Richardson?
Yes.
Member Moniz?
Yes.
Member Grant?
Yes.
Vice Chairman Beckles?
Yes.
Chairman Bell?
Yes, motion carried. All right, next case, Chelsea.
Okay, the next case on your agenda is number 18-92 for the property located at 2635/Pine Court, located in Titusville, Florida, and owned by Kenneth Mcclain. This case was brought before you with a violation of subsection 102.2 that the property was occupied with no active water source. I'm happy to report to you that the water department has indicated that the property has water restored and a valid pay arrangement was approved, allowing that the meter to be reset and allowing the property owner to get water returned to the property. So now that the property is in compliance and prior to this case reaching final resolution, I ask that this board reconsider whether they still continue to have the respondent assessed the costs that were previously assessed at your board meeting. It would be appropriate for the board to discuss that at this time, seeing as how the property is now in compliance.
So we can reassess and take it off?
That would be,
Okay,
that would be a good idea.
okay. Any questions on that? All right, make a motion, somebody.
Nobody wants to make a motion. Okay.
Withdraw the case or withdraw it and,
Gina?
Make it closed and then withdraw the assessed.
I would recommend that the board, from the testimony presented, make a finding of compliance with the prior decision of the board. As to the costs, you impose cost. Last board meeting, you have the right, while you still have jurisdiction of this case, to unimpose or withdraw the cost assessment of $446.10, or part of it, or none of it, in your discretion. You may wish to inquire as to when the defendant achieved compliance, because you said compliance should be achieved on August 10th, by August 10, 2018.
Compliance was achieved by August 8th.
Timely compliance was made for your consideration regarding your further consideration as to whether or not you wish for the cost assessment to stand as is, be partially withdrawn, or fully withdrawn. The cost assessment of $446.10, you said this defendant must pay due to the finding of violation last month.
okay, I'll make a motion on this.
Yes, go ahead.
I move that the board order its finding of compliance in case number 18-92, finding the defendant Kenneth A. Mcclain in compliance with the prior decision of the board issued in this case, and withdrawing the costs that were previously imposed of $446.10 and closing this proceeding.
Second.
Motion by Gina, second by Ed. Any questions? Roll call vote, please.
Vice Chairman Beckles,
Yes.
Member Moniz,
Yes.
Member Richardson,
Yes.
Member Grant,
Yes.
Member Herman,
No.
Chairman Bell.
Yes, motion carried. So you notify them of that, Mr. Rogers, that they're in compliance now, they don't have to pay?
What will happen next is I will prepare a decision of the board for the board chair to sign according to the motions just passed. The defendant then will receive a order finding compliance, that the defendant is in full compliance with the prior code violations, and that the board has elected to withdraw the cost assessment previously imposed. Okay. Signed, you, board chairperson, will go to that defendant.
Okay, thank you. Okay, Ms. Chelsea, new cases, please, ma'am.
Okay, so before I get into new business, I would like to just let you know that we're approaching new information in a new presentation of information. I'm going to go through a couple and close them due to the city not proceeding with them. And then I'll have Officer Crisco take the podium for his presentation on the screens that you're going to follow along with at your laptop. Not quite there yet, but we're getting there in a second. So the first one listed under new business is case number 18-102 for the property located at 225 Court Street. The city wishes to withdraw this case due to information related to foreclosure of the subject property.
And we don't need to vote on this, right?
Correct.
Okay.
For case number 18-103, the property located at 903 Gilbert Street. Again, the city wishes to withdraw this matter due to foreclosure information related to the subject property. And then we have case number 18-106 for the property located at 314 Boy Street, with Officer Crisco here to present information regarding the violations for this case.
You don't use the mouse, you said.
If you will, give us a chance. It is new. Feel free to stop us along the way. If you have any questions about any of it, just please stop us. Where are you going, Bob? Can you read it?
He can't see it.
As you can see, you all have it in front of you on your laptops.
Right.
And again, this is the last implementation of our Greenbelt project, so we're really excited about being able to show it to you today. You'll actually see the pictures are going to be a lot more clear and crisp is what you used to see. We're still going to provide the affidavits that you normally see, and as well as cost recovery as you normally see. So you will still see those, but the inspectors will go through their PowerPoint with you. And again, it is the first one, so with that being said.
Glenn, if I may,
Yes,
just
sir.
for added clarification to the board, Glenn and I have discussed possible ways to make a better presentation to the board more efficiently. So this is code enforcement's plan to make it simpler, easier for you to digest, understand the information provided to you, and make an appropriate decision. In addition, my understanding from Glenn and his staff is that they're going to standardize the presentation to where you're hearing the same 1, 2, 3, 4, 1, 2, 3, 4 in each case establishing the essential legal evidence for you to find that there was a violation. So this is an effort in efficiency. So if you'll keep that in mind, I know it's something different, but I think you'll find it, once this is absorbed by everyone, will make it easier for everyone involved to stay on the same page of the hymnal, so to speak. Back to you, Glenn.
And thank you, Mr. Rogers, for that. It's on you.
Okay. I'll stand sideways. I apologize. I got new contacts in. I can't see that at all. Should have bought my other glasses. But I'll stand sideways so I don't, you know, as long as I can see this one. All right, so the City of Titusville, Florida, Code Enforcement Board Case 18106. Our respondent is Richard Welbeck, estate, care of Teresa Welbeck. The violation address is 314 Boyd in Titusville, Florida. We mailed to the address of 2237 Slotis Street in Melbourne. Our violations will be Section 1223, junk and debris, Section 1326, overgrowth, Section 6109 of the Property Maintenance Code, 301.3, the vacant structures and land, and under Section 6109 of the Property Maintenance Code, 302.7, accessory structures, fence. Our violations, which will coincide with the violations charged, are vacant property, the allowing of junk and debris to remain on this property. The fence is in disrepair, as you'll see in the picture, it's half down, and overgrowth, excessive overgrowth. Our case summary of the Titusville Code Board Case 18106, I apologize. My initial inspection was on May 30th, and I posted the property. Our notice to the respondent or respondents went out on May 31st, certified mail. However, it was refused on June 7th. Our notice of hearing was posted for this hearing on July 30th of 2018 at City Hall and on the property. Certified mail was mailed out to the Melbourne address on 6/26 of 2018 and returned marked refused on July 8th, 2018. Our date given.
You want to enter both of these?
Yeah, when do we do that? Just hand them in at the same time? Yeah, you can do that. You can be my designated person. All right. When do we?
We're going to provide you with the affidavits, the notice of violation, as well as the notice of hearing.
Oh, I see. We can do that at that time. All right.
Exhibits.
All right. I think while the designee is turning in those paperwork for me, the date given to comply on or before June 20th of 2018. And of course, we've had no contact with the owner. The follow-up inspections, as you can see, there was a few of them, not to be redundant, you can see it on there. The results of the re-inspections was no change. The property, which has a wood privacy fence, was still in disrepair. The junk and debris remains on the property, and there's still excessive overgrowth. Our city codes define, as you know, without going into the whole litany of this, the 1223 can't keep junk and debris on the property, period, so. 1326, which is our overgrowth, anything over 12 inches is considered a code violation, and you'll see by the pictures what the overgrowth is. And under our property maintenance code, which gives us the authority to use 301.3, which is the vacant structure, it is inhabitable, and it's unoccupied, which was verified by a neighbor who I had talked with. And under our 6109, the International Property Code, which was adopted to use these codes, are the 302.7, which is the fence, which is down. And we get into some pictures, which the initial photos were taken on 5:30.
5:30.
All right,
Yeah.
2018, and you can see the excessive overgrowth. Also on 530, you can also see that the fence is down. And this is on, I'm sorry, going back to here, this would be towards Parker Street when I was talking with the neighbor. This is on Boy, facing the property north, and you can see what remains of the fence and the overgrowth. I'm sorry?
Yeah, you got your.
And more overgrowth in the front, which was taken on the initial inspection on May 30th. Subsequent inspections show since May, there has been no change to the property. Here's a notice of violation, I'm sorry, that was posted on the property on May 30th. And
Your initial compliance.
the initial compliance date photo, in other words, it was supposed to be in compliance on June 30th of 2018, and you can clearly see it wasn't. We gave it to June 30th to comply. Another picture of June 30th. Went back on July 7th.
Post up here.
I'm sorry.
As you
July 30th, I went back and posted the property for code work. And you can see, clearly see the posting in the window over there. And that's,
as of today.
that's as of today, there's no change. Our recommendation, which is based on our testimony and evidence presented on case 18106 of the Titusville Code Enforcement Board, it is determined that the respondent, Richard Welbrock Estate, is the owner of record of this property located at 314 Boy Avenue in Titusville, and is determined by which is determined by the property appraiser's office. That they are in possession or control of the property, and the estate is in violation of the Titusville Code of Ordinance of Section 1223, junk and debris, Section 1326 of the Code, Section 6109 of the Property Maintenance Code, 301.3, vacant structure, and 302.7, accessory structure fence. And we further recommend to the Code Enforcement Board that the order to the respondents to correct the violation on or before September 10th. In order to correct the violation, the respondent must remove all the junk and debris from the property, remove or repair the fence, and remove all the overgrowth, which will put the vacant structure into compliance once that's done. The order to the respondent be assessed an administrative cost of $410.88. And we have to do this as evidence.
And as to your photographs, do you wish to admit the photographs into evidence?
We're going to admit the entire PowerPoint as evidence into this case.
But the physical photographs themselves are not going into the Code Enforcement Board file?
Yes, it will be a printout of this PowerPoint will be in the file.
All right. Your subsequent counsel may or may not request or require the number of photographs and the date they're taken. I prefer that that be indicated. With your new procedure, I was able to keep up with all the photographs except those photos taken on 5/30/18. There was some crosstalk between the two of you. I couldn't tell how many pictures you put up on that date. So how many? 5/30/18.
1, 2, 3, 4.
Okay. And for clarity, I've indicated that 2 photographs taken on June 20th, 18, 1 photograph taken July 30th, 18, 1 photograph taken August 13th, 18.
Correct.
And we have cost assessment summary and writing admitted into evidence 41088.
That's correct.
Please proceed.
Okay. If the respondent does not comply on September 10th of 2018, a fine of $50 per violation per day should be imposed for each of the violations. The respondent must contact Bob Crisco, Code Enforcement Officer, at the 321-567-3770 number to arrange for an inspection of the property to verify compliance. I guess that's it. That ends it. Any questions?
I've got one question.
Sir.
It's for,
Yes, sir.
do we, is there any way that we can scroll up and down what we have on our computer screens?
No, sir.
We don't have any control?
No, sir, but it's all controlled through one. If there's something you'd like to wait on, we can always hold it.
No. As he was going along, I was trying to refresh on the violations. I was starting to read and went to
again,
the next screen.
It's on your paper right there.
If you want me to read the whole thing, I don't.
Well, no, I was just.
No, down the road, not now.
And again, this is part of that whole process. I need to know what y'all prefer. So if we go too fast, please slow us down.
No, the screen was just, it was going over
Right,
too fast. I was just trying to get used to what I was seeing over here, and you were giving the violation and not just what we see over here, the code violation, section 6109, property maintenance.
Right,
You have
which-
what it was also.
Right.
What
And
determined
actually,
the
we
property
could probably
maintenance.
define that a little better for you. Actually, what that is where the city council adopted the International Property Maintenance Code in its entirety, other than the one chapter that you never see. And basically with that is, once that's adopted, that's just a header that all these subsections that fall under there are allowed to be brought in front of y'all as a violation.
Yeah. All it was is, a lot of times we don't get a chance to read, what entails what the violation is.
Right, and
We know what the number is, but we don't know.
Right.
And that's what I
again,
was reading,
if-
and it
if
flipped
the
the screen real
summation
fast,
is
and I
not
just
a-
wanted to back it up and take a look at it again, but
Sure.
we don't have any
Like I
control.
said, we will try to do a better job of surmising the code itself. And even if you still have a question, please stop us.
Okay.
I mean, it's for y'all.
It was just a question.
I have
Yeah,
a- I
no,
have a
we'll be
question.
happy to do that. Yes, sir.
Am I correct in assuming then that code enforcement had taken upon itself to set the fines?
No, sir.
Well,
That's just a recommendation. It said should be. This board has the authority to do anything from $0 to $250. That's entirely up to the board to do. That's just merely a recommendation.
thanks, sir.
And that was for date, that said for September 10th, that's for the next meeting.
That would be for y'all's,
Assuming they don't correct the violation,
yeah, that's strictly up to
still our,
y'all. It's
discretion.
Nothing more.
but still our discretion.
I'm just asking whether they had taken upon themselves to set the fines, that's all.
The code enforcement staff is giving their opinion from their involvement or lack thereof with the owner of the property of what they feel a reasonable fine should be if you find the evidence proves a violation. You do have, as Glenn said, discretion from $0 to $250 per day per code violation. The state statute 162, chapter 162 specifically indicates $0 to $250, and the board shall consider all factors, with the goal being your fineage is designed to compel code compliance, not to punish necessarily, kind of like speeding tickets, not to make money for the city per se, but to get the violator's attention. So the statute is trying to get the board to impose an appropriate fine. City code staff is suggesting to you from their involvement with the property owner or lack of involvement what they believe the reasonable fine should be. If I may, since I won't be here any longer to give my input anymore, you have the ability to ask them, well, why do you think it should be X dollars? as opposed to Y dollars, because it may be a particular defendant that was telling them what they could do with their code and what they need to do with their behind on their property, and a lot of other individual circumstances that may have occurred in the field. That is relevant to your determination of whether the fine needs to be light or a bit heavier versus a defendant who didn't respond because they were in traction at the hospital. Lo and behold, it turns out, instead of stonewalling everyone, they weren't able to communicate. Those are the variables for your consideration to do what's fair and just based upon the evidence presented. So they're not trying to tell you how to do your job. They're just making general suggestions, and then you have the ability as the trier of fact to ask them, why do you think that much per day? Or not. You don't have to ask them a word, and nothing against the code enforcement staff. Whatever number they select does not compel you to do anything. That is just their opinion as to what they think you should choose to do. You took an oath. You get to decide by majority vote whether there's a violation or not. If there is, what an appropriate fine or other remedy would be to try and compel timely code compliance. It's not complicated. Don't get lost in all the stuff. Just keep it simple. We're just trying to get people to play by the rules.
Thank you, sir. It was most eloquently put. Thank you very much. But all I wanted was a little education about what it meant, that's all.
Yes, sir. That's it.
No malice intended.
No,
Well, Code Board, this is my last chance at you, so I'm going to take advantage.
Well, and I have one question, and it has nothing to do with this, well, it does and it doesn't. Are all of our code violations supposed to have $50 increments, or can we do like a $75?
You can do.
Whatever, in 0 to 250, anywhere in that vicinity?
Anywhere in between there. We actually tried to stay within what y'all normally do.
Yeah, okay.
Now, if it is one, we have some that acquire a little bit more of our attention than others, and we may ask that or suggest that you impose some more or less.
Okay.
Just as there may be a case where we come and we do have assessed hard costs, but we may want you to reserve those costs,
Okay.
depending on what the situation. Each case is different for us.
Okay.
So this is your chance to have input as to this new efficient system that they feel will be beneficial for one and all. So you're doing the right thing by asking questions or making comments at this point. This is your actual case, but this is the first run of the new system. So help them.
Yes, please help us out. If you liked it, didn't like it.
So, and just to reiterate what Bob said, there was no contact whatsoever
No, ma'am.
with the estate or the wife?
We don't know if they're alive or dead, right?
Well,
Actually,
his estate.
there are some other things going on that I may not be at liberty to discuss. But to answer your question, yes, both parties are deceased and there is no probate currently. But there are some other actions that we're trying to work with.
I'd like to make a motion.
Okay, go ahead.
Okay, I'll take it.
I would like to move that in this case, we accept the recommendation of the Code Enforcement Office.
But you gotta go back to the very beginning, and, because we gotta do a reading on this. You got, not just that, you gotta go back and do the first reading on this.
First reading.
First reading, on that.
Unfortunately, I don't have a copy of the first reading.
You got it there? Okay.
Oh. I move that the board issue the following finding of fact in case number 18-106 relating to the defendant, which is no longer on the screen,
Right.
Richard Wellbrook Estate and Teresa A. Wellbrook. The defendant was properly notified of the violations as alleged in the complaint. The defendant is the owner or in possession of the real property located at 314 Boy Street, Titusville, Florida. The defendant is in violation of the following provisions of the Code of Ordinances of the City of Titusville. Section 12-103, junk and debris. Section 13-26, overgrowth. Section 6-109, property maintenance. Subsection 301-3, vacant structure and land. Section 6-109, property maintenance. Subsection 302.7, accessory structure. Fence.
Second.
Motion by Norm, second by Ed. Any questions? Roll call vote, please.
Member Richardson?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Herman?
Yes.
Chairman Bell?
Yes, motion carried. Next motion, please, sir.
I move that the board issue an order of correct relating to the defendant. The address of 304 Boy Street, Titusville, Florida. The names are Richard Wellbrook Estate and Teresa A. Wellbrook. Judging the defendant to be in violation of the section of the code and ordinance of the city of Titusville is determined in the findings of fact. Given the defendant until 9 o'clock on September 7th, 2018, to correct the violations, to be written satisfaction of the Code Enforcement Board, or to appear before this board at City Hall, Titusville, Florida, on September 7th. September 10, 2018, to show cause why the violation has not been corrected and why this board should not proceed to impose the fines for the violations. The defendant is ordered to pay $410.88, which represents the cost incurred by the city of Titusville to bring this case before the board.
Second.
Oh, wait, back up. He's missed a part. Number 3. Number 3 on here. He said,
You read it.
did he say $50 a day violation?
No, that's not, that was recommended for September 10th. This is
Oh,
just the
okay.
first reading.
Okay, no, you're fine. All right, go ahead. I'm
I
sorry.
do have a question about, he said the 7th for the correction and the 10th for the...
Right.
Yes,
Should be
yes, ma'am.
Have you gone
That's,
back to the... you
we
want
would like to go back to the Friday,
Friday before.
and I thought I had changed that.
I wasn't here at the last meeting, so...
And, well, actually, she had pointed out to me as well, is we want to go back on the Fridays before the meeting.
It's a lot easier.
Yes.
All right, thank you.
Okay. All right, no, you're fine. Okay, go ahead. Motion by Mr. Herman, second by, who did the second?
Second.
Any questions? Roll call vote, please.
Member Richardson?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Herman?
Yes.
Chairman Bell?
Yes, motion carried. So they have to the 10th before we enact violations, or 7th to enact violations, okay. All right, so you got that one right, okay, got it right, all right. Next case?
Okay, there's 2 left, and for case number 18-108, the property located at 524 Dummett Avenue, the city wishes to withdraw this case due to compliance. And for case number 18-109, the property located at 1995 Fairlane Drive, again, the city wishes to withdraw this case due to compliance,
Thanks.
which concludes all the cases of new business.
Okay. All right, Mr. Rogers, Board Attorney's report.
Well, my final report is no report except on information provided to me from Chelsea. First of all, I think all board members are aware that I'm retiring. The City Council appointed a review committee of your board chairperson, Pat, myself, and Chelsea Farrell to be the review committee of applicants to replace me. There were written applications submitted, 5. We reviewed them, we discussed them. We then scheduled live interviews with the top 3 applicants. We conducted the live interviews, and all 3 of us jointly decided the same 1, 2, 3 selections of the top, middle, and third place finisher to replace me, if you will. The city attorney's office has negotiated with the top applicant and has reached a tentative contract to hire the top applicant as the attorney for the code board, subject to council agreeing that is what's in the best interest of the city. That will occur apparently on August the 28th, 2018 is when that will go before council. The new contract with attorney Deborah Bab Nutcher is your new potential attorney's name. Female attorney, well-versed, easy to talk to, and obviously has a lot of experience with code enforcement in various different ways. She's with a medium to, one may say, large-size law firm in the Orange County area, but her firm of various attorneys provides code enforcement attorney services to various cities or counties. Attorney Nutcher is subject to city council approval as my replacement. If that is what the city council decides to do on the terms negotiated through the city attorney's office, council will so decide, and your next code board meeting, you will have Deborah Nutcher sitting here instead of me. I have enjoyed my time with the board. It's been a privilege over these many years working with various code enforcement board members, because I'm very proud of what the Titusville City Code Enforcement Board has consistently done, in my view, has consistently been fair to the fellow citizens of Titusville and also to the city code enforcement administrative staff. Carry on. You all have done a good job. I want you all to continue to do a good job on that magnanimous pay that you receive. Nothing. You all are dedicated volunteers, and I'm saying this on out to TV land so your fellow citizens hopefully will appreciate you as you move about town, and also may consider to replace any of you that get tired as I have. I'm ready to go. And this appears to be my last code board meeting with you, but I'm looking forward to indirectly watching from afar how code enforcement continues to be conducted fairly in the city of Titusville. We've got the uncut jewel of the universe in North Brevard County. You all are the first line of defense in keeping our community what we love about it. Comfortable, enjoyable, not gridlock, not overbearing growth. That's beyond your purview, but our city is doing very well over the years. Keep it going. I'll stop lecturing. It's been a pleasure. Thank you.
Thank you, Mr. Rogers. Thank you, sir.
And how will you follow what goes on the code board from the beaches? Surfing.
Fortunately, your meetings are taped, and certain individuals know how to find them and show this inept technology-challenged attorney how to access those. Joe's helped me out in viewing code. I had no idea. I haven't watched one of them until Joe was helpful in showing me how you can go about doing that. So I can. Hopefully, I don't mean to offend, but I will have better things to do than sit and watch code board meetings in full each month.
Sure.
We'll see how much I enjoy the retirement, but you've done well. Enjoy it. Glenn's looking to do a better job for you all. You're working for nothing. So your time should be well spent up here getting the job done, not getting bogged down in irrelevant details. The new attorney indicated that she likes to have workshops with her clients. In other words, meeting with you all to make sure you all are of the same understanding of what your mission is and how you're supposed to go about doing it. Government in the sunshine, ethically. She's very good. She was right on top of everything as we interviewed her. I think you'll be very happy with the new attorney.
Very articulate, very articulate.
Outstanding.
And she
No
knows,
motion,
she
not
knows
just
you.
mine. It's just my report, and I'm through.
All right, well, okay, all right, but before I get to my, Chelsea, you're next, your report.
I think that the board attorney did a great job summarizing everything that happened with our selection committee and identification of the subsequent attorney who will be coming on board. And I look forward to working together with her and you all. And thank you, Attorney Rogers, for your 32 years of service here to the city of Titusville. We greatly appreciate it, and I know I personally appreciate working with you and all of the training you have given me as a younger attorney here. So thank you very much.
You're welcome.
And again, thank you, Rick. It's been a fun, short time for me, though. You've decided to go surfing, and well-deserved. Please
I'm
enjoy it.
excited for all of you. I think this new procedure is a little burdensome at first blush, but work with staff on this so it will work for all of you. No, they don't need to read you the same code sections you hear over and over and over and over again. But now, if you're unsure, it's an obscure code section you haven't heard about lately, then you can just say, hey, what specifically is the rule you say this person violated? They can call it right up for you. Right. So you're going to have information at your fingertips. But staff needs to know what information you need and what information you don't need. You've got to have relevant evidence. People are innocent until proven guilty in this venue as well. So the city has the burden of proof, not like criminal court, by preponderance, more likely than not, that a code violation occurred to convince you. So their job is to present adequate evidence to each of you that you can make that decision, up or down, code violation or not. So just keep your eye on the ball, so to speak, and if they start going off track, let them know. Why are you telling me this? Or if you feel you need extra information, ask them. But your workshops with your new counsel, you want to develop a good working relationship with your new counsel as well, so you'll know what you need to know and know what the chafe is that you really don't need to know, and you got better things to do than to listen on infinitum about things that really don't matter.
You have anything else?
Just if I could get any comments on the PowerPoints, that whether if you did like them, thumbs up or down, or
Yes.
thank you. And again, like I said, we're just trying to make it a better case presentation for y'all to see what we deal with.
The one thing is if the staff member could stay at the microphone, because I imagine the people couldn't hear him.
Yes, sir. I didn't know he had the wrong contacts in. Okay. But yes, sir. They will actually be right at the microphone from now on.
Okay, all right.
But with that, ma'am, that would be it.
Okay, all right, thank you. My report now, Mr. Rogers, I want to thank you for all your years, and I've been on this board now 10 years, so I've gotten to see you for the last 10 years, and I appreciate that. And we will miss you, because you have at least till the 10th of September to be around a little bit. Until the new person starts. We want to plan a little luncheon for you. To say thank you. Well, it doesn't make any necessary, it's just we would like to do that. You pick a date and we'll work around your date. And yes, I was in on the interviewing with the new attorney, and she also has written some code things that have helped the boards that she's been on, and she knows Glenn, so she's worked with him in Winter Springs and things. So it'll be interesting. A new concept with the computer, a new concept with a new attorney, and so we'll be getting there. And from what I hear, somebody told me, and I can't remember who it was, but the code board has power in this town. So we have power. Whether we use it or not, I don't know, but we have power. But thank you, and we wish you well. Enjoy yourself. Spoil yourself, and let Sue spoil you too, and you spoil Sue. But thank you. All right. Any board members report?
I've got one.
Go ahead.
I've got one thing, and it may be irrelevant, but in my travels, I travel through Royal Oaks Golf Course and all. That has been under our eye several occasions. Right now, the weeds are, when you drive through there, you're staring into weeds. They're that high.
Ed, you can't go any further. As a code
that's
board
what
member,
okay,
you can't
just stop me
initiate
right
any
there.
kind of code enforcement.
Okay, I'm sorry.
Well, there's several things in Titusville, but we can't discuss it here, so.
Yep.
All right, anything else? All right, thank you. And I like your new vehicle. We're waiting for a ride. They have a new SUV for code enforcement, it says on that side of that truck, car, whatever. Looks good. But thank you very much. And thank you for participation in Friday night's party.